Let's just remind ourselves of where we are in our study of the four quadrants. We started with the damages quadrant, spending a substantial time reviewing compensatory, nominal, and punitive damages. We are now in the realm of what we are calling coercive remedies. Our look at coercive remedies will involve at least three different types of injunctions. The first is the temporary restraining order. The second is the preliminary injunction. And the third is the permanent injunction, a specific subset of which is specific performance, which has to do with an injunction pertaining to the performance of a contract. You'll note that both the preliminary and permanent injunctions indicate here that there may be an appeal taken to them. You'll also note that there is no such indication for the temporary restraining order or TRO. That's because TROs are not appealable, generally speaking. Preliminary injunctions and permanent injunctions, however, may be appealed from, and we'll talk about, during our coverage of coercive remedies, those appellate processes. At the end of today's lesson, I'd like for all students to be able to understand the function of injunctions, including the situations in which they are typically used. I'd also like students to be able to distinguish types of injunctions, including the types that we just reviewed. Students should also be able to explain injunctions as a remedy distinct from damages, including how our understanding of damages principles impacts our understanding of coercive remedies. And finally, I want to be sure all students understand and can identify and analyze the considerations related to the issuance of our focus today, and that is a permanent injunction. Now, to get us started, I'm going to ask you to just put everything aside, close computers, and give me your full undivided attention. I'd like for you to consider the following scenario. Imagine that you are an associate in a law firm and that you have just received a call from the managing partner of the office. He tells you that he'd like you to come right in to his office to partake in a conversation that he is having with the client. You quickly drop everything and run into the managing partner's office, and the client describes the following. The client is a developer of certain technology being developed for self-driving cars. It's the CEO of the company that is the client on the other end of the phone. The CEO explains that one of its chief engineers, who had been developing the technology, has, without notice, just left the company. He further explains that, using a quick review by his IT folks, he has determined that this executive has absconded with at least 15,000 confidential records of the company. He further tells us that he understands that this engineer has taken up shop at another company, a competing one, who has just purchased a new company that has the intention of developing the same type of technology. In other words, a competing project. Now, before we go any further, I'd like to ask you, What questions do you have for your client? Why do you want to know the answer to those questions? What is it that you think the client wants and/or needs? I'd like you to think about those questions and this problem from the following advocate's perspective. Number one, do you see time sensitivity to this issue? If so, what is that time sensitivity? Where does it stem from? What are you worried about? And how does that instruct the options that might be available to the client that you would want to discuss with the client? Number two, I'll ask you to think about notice. At the beginning stages, what do you understand about any potential action that you might want to take, and what notice requirements exist? Do you know who to sue and to whom you need to give notice? Is there a way that you can do this without giving any notice at all under the circumstances, and in fact, because of the circumstances? Number three, I'd like you to think about evidence. What evidence, documentary or otherwise, do you think you need to support your case? And when I say case, I'm not simply thinking about the case on the merits, but I'm also urging you to think about the case on any preliminary relief that you might think about pursuing on behalf of the client. Further, I'd like you to think about a precise answer to this question. What is likely to be lost before a trial on the merits can be had? In other words, what harm will be suffered between now and an eventual trial? I'd further like you to ask that if you are considering any provisional relief, what might be lost between now and the time of a hearing pertaining to that provisional relief? I'd also like you to consider the merits. How likely do you think it is that your client would prevail in the matter? And again, what is it that the client seeks at the end of the day in conjunction with this matter? Finally, I'd ask you to consider any ethical questions that may be raised by either the situation and/or your representation as it pertains to the ethics. And I'd also like you to think not just about the provisional or more permanent relief that you might seek on behalf of the client, but what strategies might you be bringing to bear to bring about what the client wants, perhaps even short of a full trial? Now I'm going to ask you to take off your advocate's hat and think about this from the perspective of the court. And let's think about the same issues that we thought about as an advocate. Now, as a judge, I'd like you to think about the time. What is the time that the client, the party, has asked for a court's decision? What is the time in which the court needs to turn around a decision? If we're talking about provisional relief, how quickly is a hearing likely for you? like you to think about notice and due process concerns. What due process concerns do you have surrounding the potential available forms of relief? Do you have due process concerns surrounding a TRO or surrounding a preliminary injunction, particularly if notice has not been given? What evidence do you think you need in order to grant relief to the company who has essentially developed arguable trade secrets that may have been stolen and now may lie in the hands of a competitor? What is likely to be lost? What is the harm that might be suffered between now and the time of that first TRO, between now and the time of a potential preliminary injunction, between the time of a TRO and the preliminary injunction, and between the time of a TRO and what arguably would be the final trial on the merits? And finally, what are the merits? One of the things that I want to be clear about is just how powerful and flexible a remedy an injunction can be. Coercive remedies are simply extraordinary, not only in terms of time, but also in terms of their effectiveness. And certainly where you are presented with cases in which there is a true emergency, or even if not an emergency, but where the relief that the plaintiff seeks is the cessation of conduct by another that causes harm, that the injunction, coercive remedies, absolutely are a powerful tool. They are also so powerful, and in fact, one of the reasons that we worry about the power of this remedial device is that their consequences can be sweeping, even to the point of shutting down the operation of a business or otherwise dramatically affecting the rights of parties involved in what could potentially be an irreversible manner. The fact of the matter is that some of the available relief that can be sought, especially that in the earlier stages of a case through coercive remedies, stands in contrast to our normal processes. And all of that is important to know, not only as an advocate pursuing this kind of relief, but as an advocate defending against it. In addition to all of the extraordinary power that comes from injunctive relief, remember that perhaps the most powerful is the consequence of failing to adhere to an injunction if issued, period. As you may recall from our earlier conversations and study on damages, a main distinction between damages and coercive relief is that coercive relief results in the imposition of a contempt sanction where it is not followed, period. In other words, a matter of equity carries in personam as distinct from in rem jurisdiction. And certainly while a party might prefer an equitable remedy, in part because of its power and in part because of the consequences that are attendant to failing to comply with an injunction, legal remedies are still preferred. That is to say that, typically speaking, legal remedies will be more readily available than equitable remedies will be. And in fact, as we'll see, one of the prerequisites to obtaining an equitable remedy is that the legal remedies are inadequate. In fact, while we're on that concept, let's talk about when you would have the ability of a court to employ an equitable remedy. It is said that there is such a thing as traditional equity jurisdiction or substantive equity. Now, you'll remember that we discussed the fact that equity jurisdiction is a bit of a misnomer post the merger of both courts and the onset of the federal rules of civil procedure. However, there are some cases where we can identify the availability of an equitable remedy depending upon the subject matter of the claim. So, for example, claims that involve guardianships, trusts, mortgages, probate, the enforcement of liens, quiet title actions, and shareholder derivative actions are matters that are said substantively to be equitable. And the remedies that inure from these actions are equitable. That said, a claim does not need to be labeled as equitable in order for a party to avail themselves of an equitable remedy, otherwise known and sometimes referred to by courts as quote-unquote equity jurisdiction, period. In this sense, we talk about equity jurisdiction as simply a reference to the idea that equitable relief would be appropriate given the inadequacy of a remedy at law. So I'd like to go back to distinguishing the different types of injunction. And for the moment, I'd like to focus on the types of injunction on the basis of where they fall in the claim and the type of relief that is asked for. 3 weeks work. Now recall, the first injunction that we're talking about is the temporary restraining order. The second is the preliminary injunction. And the third is the permanent injunction. The first of these two, the temporary restraining order and the preliminary injunction, are what we call forms of interlocutory relief, meaning that these are forms of injunctions that a party can avail itself of prior to a final trial on the merits. And so the context in which these two forms of relief are used is really one in which a full record has not been developed, no discovery has taken place, And really, it is the circumstance that precipitates the filing of these two powerful forms of interlocutory relief. Now, in re-COVID helps us tremendously set the landscape for the first of these two forms of relief. And I'll ask someone here to just get us started talking about what the COVID case had to do with. Correct. The COVID case had to do with the filing of an interlocutory injunction where two religious leaders were ultimately attempting to obtain relief from restrictions that had been imposed on them by the governor of the state of Delaware in their respective houses of worship. And ultimately, what they wanted was those restrictions lifted. And this is fun because many of you probably remember the various restrictions that we all were privy to and had to obey, some of which even involved our religious institutions. And so here we can really understand the imminency of the circumstance. And so the court helps to walk us through the circumstance where these two religious leaders were attempting to seek relief from those restrictions by filing an interlocutory injunction. Specifically, the leaders here had sought a preliminary injunction. And so this allows us to set up an understanding of the two types of relief. Let's start with what we call interlocutory relief. There are two forms of interlocutory relief. The first is the temporary restraining order we've discussed, and the second is the preliminary injunction. They're interlocutory in that they take place prior to a full trial on the merits. And there are other aspects of each of these forms of relief that we'll talk about. The first, as we'll see, is that this is expedited relief. In other words, the relief by the court is quickly done. Not only that, the relief that is provided is for a short term. It is by no means permanent. Again, it is interlocutory in that it is given before a final adjudication on the merits of the case. And finally, I'll say that what distinguishes these types of injunctions from permanent injunctions is that they really are available in only special circumstances when a plaintiff needs immediate court action to avoid irreversible losses while waiting for the trial on the merits. The other aspect of this, and certainly it is the case with a TRO, is that these are really emergency kinds of remedies. Not only are they emergency because they are necessitated by some substantial irreversible harm, but they also happen fast. And as I mentioned, again, short-circuiting much of the due process jurisprudence given what we normally see in the American legal system that pertains to the notice that a party must have in order to adequately defend itself. In other words, it is often said that interlocutory relief of a temporary restraining order or a preliminary injunction is extraordinary relief requiring a strong showing of necessity. And we'll talk about what that level of proof really is. So, in the COVID case, the court illuminates that one of the parts of the showing must be that there is a threat of harm that is both irreparable in the sense that it is not fixable during the remedial phase, and imminent in the sense of likely to happen before a later stage of the case. Without this, the Delaware court tells us, a TRO is not necessary. Period. So let's talk about what the standard is for actually prevailing on a motion for a TRO and its closely related interlocutory cousin, which is the preliminary injunction. And while the standard is different, because of the timing, it really is a slightly different standard. Generally speaking, and the COVID case tells us, in order to, on page 66, prevail on a motion for TRO, the moving party must demonstrate that it has a colorable claim on the merits, that it will suffer irreparable harm if relief is not granted, and that the balance of hardship favors the moving party. The court further tells us that of these three elements, that the presence of imminent irreparable harm is the sine qua non of the issuance of the TRO, and that without a showing of irreparable harm, there's simply no need for a court to act at such an early stage of the case, because the remedy truly can await the remedial stage. Now, eBay sets out the standards slightly different and in a manner that perhaps tracks what I have on the slide. eBay says that according to well-established principles of equity, a plaintiff seeking an injunction must demonstrate that it has suffered an irreparable injury, that the remedies available at law are inadequate to compensate for that injury, that considering the balance of hardships between the plaintiff and defendant, a remedy in equity is warranted, and that the public interest would not be disturbed by a permanent injunction. Now I want to stop and ask you a bit about this first issue, the idea that the moving party has a colorable claim on the merits. Now, why would it be that a court would be inquiring as to whether a party might be successful on the merits at the earliest possible time in the case, period? In other words, if we go back to my trade secrets case, where the engineer is just running out of the door, comma, how could a party possibly know what the ultimate outcome is on the merits of the matter? In other words, whether you would prevail in making the claim, and why would the court care? Question mark. The reason is, of course, that a court has to care. Remember the procedural posture of an interlocutory order taking place before a real plenary trial on the merits. Though we cannot know at this stage, period, it has to be the case that the court has some inkling that a party might prevail on the case. And as we move into this discussion, we'll dig deeper into how certain a court has to be in order to have this particular element pass muster. But it's essential that a court investigate the possibility that a party won't be likely at all to bring this claim, that this claim will not be successful no matter how much the party complains about it at this early stage. Let's move to that second requirement of irreparable harm. Now, what does the court say that it means when talking about irreparable harm? Question mark. Yes, the court clarifies that ultimately irreparable at the stage of a TRO means essentially that the problem can't be fixed during the remedial phase. In other words, before trial, and that the harm is imminent in that it is likely to happen before a later stage of the case. Period. So this irreparable harm requirement at the earliest stages of the case is particularly important, as the court calls it, the sine qua non of the TRO, because we know that at least the second type of interlocutory injunction takes place where there's been at least some ability to collect more evidence. And so the court's going to be infinitely more comfortable and really looking to see, given a party's request of relief this early in the case, is there something that between now and the time that the court could set for a preliminary injunction hearing, it has to do, it has to act on, because if it doesn't, it won't be able to act on at all. The harm will have already been done. Period. I want to talk about this third requirement, that of the idea of balancing, weighing harms. And I want to make clear that what we're talking about here and the interests that we're trying to balance are specific. What we're looking at is the hardship to the plaintiff, the moving party, if the injunction is not granted, versus the hardship to the defendant if it is. So here is where the court is ultimately taking a look, not just at the harm that might befall the moving party, but essentially the costs and hardships to both parties. Ultimately, the hardship to the plaintiff, in order for the TRO to be granted, has to favor the grant of the TRO. And so that is ultimately the balancing act that the court is doing here. And finally, though the court in Delaware doesn't mention it, public interest is an important part of this analysis, and we'll look at different aspects of public interest and how courts consider that throughout our study of injunctions. So hopefully this graphic helps us to visualize what is happening along the continuum from the point in time that you're on the phone with a client up until the time of trial. So if we start in this first phase between now and a TRO, again, that is the shortest amount of time within which we can seek the kind of immediate relief for irreversible harm. And we'll talk about issues pertaining to notice and issues pertaining to what it is the court needs to issue upon issuance of a TRO. But it is the coercive remedy that would come first in time if in fact what you're dealing with is really an emergency motion. And so we'll talk about the showing, and in fact we'll see with eBay what is required in order to make out that showing. So we're talking a matter of days. Typically speaking, there is also this other intermediate period of time, again, before a full trial on the merits, but not within days. Preliminary injunctions are usually issued after a little bit of a longer period of time. So if a party in fact seeks, and it can seek all three of these forms of relief at the same time, and the court, for example, issues the TRO, a court will typically set the hearing for preliminary injunction on the heels of that issuance of the TRO, but leaving enough time for the parties to come back to actually be heard in a little bit more detail, right? So that TRO issued in a number of days, we know that, maybe even hours, we know that these are the kinds of situations that courts are particularly leery of because they are issued without the court having the opportunity to hear as much evidence, certainly, as it would prefer. And to the extent, as we'll learn, that TROs can happen without notice and ex parte, without the presence of the adverse party, it is essentially a critical thing for courts to be able to come back, right? To say, okay, let's put a pause. We sometimes call that let's pause the status quo, and we'll talk about the use of that terminology as we move along. But let's pause the status quo so that we can come back to hear a little bit more evidence so that the court actually understands exactly what's at issue, exactly what the irreversible losses are. And part of what the court is trying to get a sense of, as of the time of the preliminary injunction, is what is it, not that's going to be lost forever, but what is going to be lost between the time of the preliminary injunction hearing and the time that a full trial would happen. And so each of these phases is distinct from a procedural point of view, distinct from a substantive point of view, though we'll see there's tremendous overlap in the substantive entitlement to one of these modes of relief. But the inquiry by the court is slightly different at each time, and some of that has to do with the timing. The Henry COVID-related restrictions case further explains the difference between the TRO and preliminary injunction. Again, noting that, as with TROs, these are often described as extraordinary forms of relief, period. As the court indicates, it is not just in the colloquial sense of being amazing that we care about the extraordinary or out of the ordinary nature of the preliminary injunction, period. Rather, it is again because these practices are a diversion from a regular practice of due process, period. Perhaps the one way in which the COVID case outlines the difference between the preliminary injunction and the TRO is in the greater burden on the plaintiffs because, as of this moment, the parties now have had an opportunity to create a preliminary factual record, period. Ultimately, these forms of relief are different in that they are both sought before a full trial on the merits, period. So not only is the procedure that is used for TROs and preliminary injunction unusual, but the duration also leaves something that is quite distinct. So for example, a TRO lasts only days, typically until a preliminary injunction hearing, whereas a preliminary injunction can last for months or even years, and certainly until a final adjudication on the merits is established by a trial. And let's not be confused by a permanent injunction. It does not necessarily mean that it lasts forever, though it can. What we typically mean when we refer to a permanent injunction is that it comes after a full trial has actually been had, though, again, it can last forever.